Both bills are being heard today. If you would like to speak on a bill and have not already signed the sheet, come up here now and please sign the sign-up sheet for us. We don't have a quorum yet, do we?
Isn't it 4? Is it not included here? Is it 5?
As we wait to get a quorum, we will go ahead and slowly get started. Senator Watson, you mind open us up in a word of prayer once you catch your breath? Which mic are you? Okay, 13.
Number 13. Please, let's go to prayer. Dear Lord, thank you so much for looking out over us and keep us safe in our travels and help us make appropriate decision in your eyes. And continue to look over us throughout the day and throughout our session days here. In Christ's name I pray, amen.
Thank you, Senator Watson. Before we get started, I want to recognize some students from Georgia State Law School that are with us today, some 1Ls, 2Ls, and 3Ls. Will y'all please stand up? And they are joining us. Yeah, you can give them applause. They came down the street to watch us in action, visit us here at the Capitol today. Thank y'all so much for being with us. I know some of y'all have classes, I think at 6 you got to get to, so I'm hopeful we'll get you out in plenty of time. If not, of course, you're welcome to leave whenever you need to step out. And we have more judges. We will hold until we get a quorum, so if you'll just be at ease for just a minute. Once again, recognize our judges for the day that are up here. Judge Bill Hamrick from Coweta County, Judge, and Judge Burt Guy from down in Brunswick. Once again, there's no court taking place in Southeast Georgia this week, but thank you all so much for joining us today. All right, we're going to go back on the agenda with Senate Bill 359. Senator Albers, we have another substitute. This is a bill we've heard the two previous hearings. We didn't hear it Monday, but last week. We're working off substitute, which is LC 490857S. Is that what you have? There we go.
That is correct, Mr. Chairman, and hopefully third time is a charm.
You took my one-liner. If you will walk us through the changes that you made since we were here last.
Yes, and I'm going to ask Mr. Mike Carlson to join me again, if that's okay. If you remember, he is with the Fulton County District Attorney's Office, and I want to thank him and the Madam DA and others who have helped us. And as we begin to walk through the changes in the version you have in front of you. I want to thank all those who have provided feedback, both on this committee as well as we have heard from judges, from other folks, prosecutors, et cetera. So I think that we've gotten to, I think, a very good place, and we're certainly open for any other minor tweaks, but I think we're getting very close to a good finished product. So on the original bill, or maybe the section substitute bill, there were some concerns on what was the original line 84, and we struck those lines, and those lines were specific about evidence. And if you remember, there was a couple of folks that came up to speak, and it was under the area of 24-1-103. We had added a section 3 to that bill, and we took that out, and but the original language was, when no ruling has been made on the record concerning omission or exclusion of evidence, a contemporaneous objection or offer of proof must be made to preserve a claim or error of appeal. In feedback that we received from different folks, we elected to strike that from the bill. And then, not too far down from that, under subsection E, there was a question very specific to whether the court should address the admission or exclusion of evidence, and we changed that to a may. Thank you to the feedback again from this committee. That was on the original bill of 201. On this bill, it is, one moment.
That's 216, is that right?
That is correct, yes. Thank you.
Well, hold on. I think it's actually 217.
Court may, yes. It's the very last word of line 217. Thank you.
While you're there, is there any reason the should, prior to that, where it talks about a motion limine should be filed prior to trial, shouldn't that also be a may on line 217?
If I could ask Mr. Carlson to assist.
Certainly, and thank you, Mr. Chairman, and members of the committee. Both our Supreme Court and any federal court that's commented on it that we've been able to find for years, as well as the commentators, take the position that if evidentiary issues can be vetted pre-trial, they should be. This language actually comes from another state statute. So one reason it is in there the way it is so that our courts can rely upon the precedent of other high courts to do that, which of course is part of the reason the preamble was added to our evidence code a number of years ago to comply with cases like Haley versus State from our Supreme Court. So we have that admonition as recently as 2020 in a Georgia Supreme Court case, Morgan versus State. We have that in such federal cases as Palmer or Palmer v. Riverside, U.S. v. Bulger. But then we have another consideration there. Particularly, we're going to change our expert witness standards soon. We know that this bill, and along with another bill, may lead to our Attorney General having a gang prosecution unit, and with more and more activity in the highly complex areas criminally of racketeering cases and gang cases, that really necessitates for fair adjudication and for the victims to be able to exercise their appellate rights, having these matters heard pre-trial. And we recall, and we have Executive District Attorney George Jenkins here from our office who can comment to it as well. When our Supreme Court had issued admonitions about the need to have motions for new trial heard, and then finally came down with a rule on the matter. So the question, of course, is what is the better venue to have a rule that complies with the recommendations and best practices from our appellate courts, from the federal appellate courts? Should it be done in this chamber, or should perhaps it be done by our courts? And the position of Madam District Attorney and here in this bill is that it should be done by the
So is it
legislature.
your intention that should is in essence a shall, that if a party can reasonably anticipate an evidentiary issue, then they shall file a motion in limine?
Don't know that it's a command that strong. It reinforces the recommendations from our courts. May would provide the right, but that's a right that already exists. So the question is, which is the better practice and what should be the recommendation vis-a-vis a statute?
And that's my challenge. Is I don't know what should would mean, because if it's not mandatory, if there's nothing waived by not doing it, then I think may seems to be more consistent with the rest of the code. But that's just my thoughts on it.
That is what our recommendation is, but certainly, May would obviously provide that statutory encouragement as well.
Right. Okay.
Well, Mr. Chairman, if it so pleases the chairman, I'm sure we can make an amendment.
Okay.
Thank you.
You can keep going.
All right, and then one more area that we struck was originally in line 257 of the bill. That was under Section 9, and specifically 2413.8. You won't see it in the new version, but we did remove what was subsection D, which was nothing in this code section shall limit or prevent the Uniform Superior Court Rule 9.2 from being amended or modified as authorized by law. That was just taken out by feedback we received from several folks, and it was reordered, so you just do not see that in your substitute anymore. We also made some other changes that I'm going to ask Mr. Carlson if he can take us through as well.
Certainly, and we also have, who can speak on this as well today, again, John Floyd of the Bondurant, Nixon, and Elmore law firm, a nationwide racketeering law expert who's also argued those cases in front of our Supreme Court, argued the constitutionality of the Street Gang Act along with yours truly. So as to the change in the new Section 5, and let me see which lines that is presented on, which now appears as Section 4, page 5, starting at line 111. This is an additional finding of the General Assembly. This supplements the current preamble or the statutory preamble of the code to make a declaration that criminal street gangs exist as criminal enterprises. It states clear facts about what gangs do, and certainly that came out during Senator Alber's hearings this summer, and as well as in the House. But that also provides additional scaffolding for the venue change provision that comes later in this statute. So then we move forward. The venue provision was updated to address any number of concerns in terms of the drafting. And that is at Section 6 now, starting at line 127. It adjusts even further the new venue provisions to the specific charging sections of the Street Gang Act to which they would attach. And we went with language that directly connected the primary charging provision, which has the definition of criminal gang activity, which is a term of art within the code, to those charging provisions. So those were the changes made there, and then some additional from what was the original substitute version, some additional language that didn't seem to be needed to tighten this up so it pertains directly to the crime. Then as we go on to a change that was recommended by Prosecuting Attorney's Counsel. I would have to see exactly where that is, but it pertains to the firearms offenses, changing the word any to a, so that individual charges could be brought for each possessed firearm. As we go now into what is the proposed evidence code provision in what is now Section 9, there has been an addition there, subsection F made, that is to cause this, state that this section is not the exclusive means to admit or consider evidence described in this code section. Georgia has 3 code sections like this patterned after the federal rules of evidence, one that is an independent Georgia provision, and they all end with this last section. That would be there at line 270. And then at section 12, and there may be one additional amendment needed here, and I have not had a chance to confer with Senator Albers on this in an abundance of caution. The changes have been made so that the substantive provisions of the statute have an effective date for offenses committed on or after July 1st, 2022. but that the procedural provisions of this statute, which are not subject to ex post facto restrictions, could go into effect immediately upon signing. We double checking real quickly here as far as the substantive sections that would probably, with the realignment, include sections 3, 6, and 7. I'm going to ask my colleague, Mr. Jenkins, to double check me on that, but I believe 7 is a substantive section as well, that just when things were realigned, that might have been missed in the drafting. So those were the additional changes that went in.
Mr. Chairman, I think, as I mentioned earlier, I appreciate the feedback from all of the interested parties up to this point. We continue to hear a couple of minor things. In fact, I had a conversation right before this. I think somebody wants to mention something on video evidence. But in general, I want to thank everybody for their feedback up to this point. And I think, like I said, I believe the bill's in very good shape now.
I have one other question. Section 10, and it does deal with the video evidence. We use the word remotely on line 293. No trial shall be conducted remotely in looking at civil trials without consent of the parties. And then we use the word remotely again on line 294. In 303, we say remote proceedings. Yet in other places, we say video conferencing. Is there any difference between video conferencing and remote hearings, at least with the way this is drafted? Because the reason I bring that up is what's important for people, especially in the civil trials, is it requires the consent of the parties to have a trial conducted remotely. Is that the same as a trial that's conducted via video conferencing? Is there a difference?
I don't know that there was an intended difference in the draftspersonship here, no.
I don't know which one's better to use, and if anybody has any thoughts, there's people signed up to speak, I'd be interested to make sure we're consistent with it.
Mr. Chairman, might we ask Legislative Counsel for their input? Would that be okay?
Yeah.
Sure, I don't have an opinion on it. Really, I'm just looking through to make sure we square it up. It does make sense that they should be consistent. So if there is a preference in one direction or the other, we can amend it to get them aligned.
How do we say it in the Superior Court rules? Do we know? Is that better to be consistent there? Well, we can come back on that. Okay.
I would think, just for clarification, that we'd want to say video hearing, because we had folks during COVID that were literally 2 rooms away that were on video just for distancing purposes. So video might be more consistent as opposed to remote.
Okay. We have a question. Who has? Is it Senator Parent?
5, yeah.
Okay.
Thank you, Mr. Chairman. Thank you, Senator, and for all of your hard work on this. I can't remember if we went over this at a prior hearing, but the area where I'm still having a little bit of heartburn is around the mandatory minimums, which is sort of, we kind of started walking back some of those steps. And then I guess in, my tenure here, we have walked a lot of, criminal justice reform forward, and sometimes there have been some mandatory minimums, most of which I've opposed. Can you talk to us a little bit about the rationale for the mandatory minimums and why you think those are important for meeting the goals? That's my area of concern, just among the other good things you're trying to accomplish here.
Yeah, certainly, Senator, and I'll begin and I'll let Mr. Carlson continue. I believe, when Governor Deal first came out with criminal justice reform, he used the words that we have to separate those that we are afraid of versus those that we're mad at. And we specifically focused against nonviolent offenders, and we wanted to give people a second chance, and from that came accountability courts and way we deterred people, and I think it became a model for other states, and I think even part of the feds adopted it. However, the folks in here are your violent offenders. These are the people we are afraid of. They are the ones who their recidivism rate is off the charts. They're the ones that are habitually and continually committing crimes and bringing harm to our families. So in the spirit of what criminal justice reform was all about, I think this gets back to those that we're truly having the biggest problem of, that are the violent and the worst of the worst. And I'll let Mr. Carlson continue.
Certainly a great deal of the testimony this early or late last year and from Madam District Attorney centered upon violent crime involving firearms. And this is certainly an area where criminal street gangs are at the height of that sort of activity, with the Georgia Bureau of Investigation telling us 70 to 90% of the violent crime in this state is gang motivated. That, of course, parallels federal studies that have been around for years. So if we look at where the increases in penalty and the recidivizing is here, it is in areas where criminal street gangs specialize: gun violence, domestic violence, acts of violence. And of course, we know gangs lead in every other type of crime that people fear as well. So certainly these sorts of provisions were an outgrowth of the testimony provided by Madam District Attorney and others, both in front of the Senate and the House, and it's not a general matter. And I will say that under Governor Deal's leadership, penalties were increased under the Street Gang Act, and the character evidence provision, similar to what you see here, was added for prosecutions under the Street Gang Act, which is unique to Georgia. Both of those were signed into law under Governor Deal's leadership.
Thank you.
Senator Kirkpatrick.
Thank you so much for your work on this bill. I definitely want the people we're afraid of put away. And I did have one question, and I think I've asked this before, so forgive me if I'm going over territory that we've already covered. But I'm still struggling a little bit with the difference between forcible felony and a domestic violence felony, and I just need a little more explanation on that. On lines 101 to 102, it talks about a forcible felony. On 103 to 105, it talks about domestic violence felony or involve the occurrence of an act of family violence. I don't know if that's intended to capture certain misdemeanors or what the intention was of that.
Looking at the draftspersonship here, it appears that a new definition was added here in this provision at Section 3, and that was to capture a new definition, which would be domestic violence felony. So the intention, of course, is to make sure that those who commit domestic violence are subject to the provisions of this section in terms of relating to possession of firearms by convicted felons and first offender probationers. Whether or not the statute repeats there, as a matter of interpretation, I think it comes down to which side this committee wants to err on, whether we maintain the additional definition of domestic violence felony as a factor that can be considered, or actually a matter that applies, or not, or whether we just want to stay with that forcible felony language that's in there. Again, some of the most severe domestic violence homicides any number of the people sitting behind me have seen have involved gang members. So certainly from the matter of policy, it would seem to make sense to leave that in there. Does that overlap with the other section? It might, but that would not be a matter where someone could get sentenced twice for the same offense.
Senator Parent.
Thank you. Just follow up quickly. When you're talking about domestic violence committed by gang members, educate me. Are you saying that some of these DV incidents are being committed by people due to their gang membership, or people that generally are in gangs are more likely to be domestic violence abusers?
Well, outward public displays of violence in reaction to some perceived disrespect is a strong location. Well, very often it will get back to the fact that that is an expectation of the criminal street gang involved. So in a case that was handled in Cobb County by your current speaker, a member of a criminal street gang, after his wife broke up with him, beat her over at least 100 times on separate strikes, according to the pathologist prior to. Certainly a motivation there was the fact that this Bloods gang member had been shown disrespect. So certainly acts of domestic violence are frequent, and he had a long history of domestic violence behind him. And I won't get into all the details now, but they were tragic and heartbreaking. So again, a factor to consider when looking at whether or not we are moving into areas like domestic violence. Is that something that is going to help us further encroach on criminal gang activity? Absolutely.
And not limiting by just criminal gang activity, right?
Correct.
Really, what this is saying is these are some folks that are consistently acting bad, right? It's not that they went and took some drugs and didn't hurt somebody. These are people that have brought harm to folks, right? And this is connecting the dots between them and those that are now carrying firearms who are consistently committing other acts of violence.
And which gets us to areas of heavy recidivism, and of course, we have sexual offenders, gang members, and of course, domestic violence abusers.
Any other questions from the committee for the author or Mr. Carlson? Senator Jones?
Two questions on sticking on that particular section, lines 98 through 107. So they have the possession of a firearm. Do they have to be involved in a violent felony to get that mandatory minimum, or is just the possession only that would trigger that?
If you are a convicted felon, you cannot possess a firearm.
Correct.
Right. So I think if you read this, well, I'm not going to read it out loud, but I think what it's addressing here is if somebody is a convicted felon and they have a firearm, that we're going to make sure that they have no less than 5 years in prison. Now, I know there's other bills coming through. In fact, we just had one from Senator Hatchett in the Public Safety Committee addressing multiple weapons as well, and I think that Mr. Carlson alluded to that as well, and that might be a potential addition, or just wait for another bill.
So and Senator Jones, and just underscore Senator Albert's point, as far as those lines from 98 on down, that is the possession by the convicted felon, and then under certain circumstances, then that penalty increases there. And the circumstances being the forcible felony provisions.
They had to have been convicted of a forcible felony. The original conviction had to be one of a forcible felony.
The subsequent has to be under this statute, I believe. I'll defer to Senator Albers on that.
Yeah, the first conviction has to be a convicted felon or first offender probationer. It's the subsequent ones under subsection 1 and 2.
Correct.
So it would have to be a forcible felony or not on the subsequent act to get the mandatory minimum is what I'm asking.
Correct.
It has to be.
Right. I think if you look under subsection 1 or 2, well, I'm getting a head shaking.
Yeah, I know.
Yeah, I'm not sure that's accurate.
The controlling language is provided that.
The felony for which the person is on probation or has been previously convicted is a forcible felony.
Right. Previous one is a forcible felony.
You're right. I said that backwards. Thank you. My apologies.
So that's what I'm getting. I understand they had a forcible felony, and now what I'm asking is, they have the firearm. I got it, and they're bad. They had a forcible felony. I'm asking, is that all that is required? Is that they just had a firearm to then get to no portion of their sentence can be stayed or probated?
That is correct.
Okay.
That's
So then that then goes into my second question. Under those circumstances, have we kind of looked at, even if you just have anecdotal stories, are judges abusing their discretion in this type of situation? Do you think they're abusing their discretion to where they're, for lack of a better term, letting people off light? You know, you understand what I'm saying?
I'm going to let the district attorney's office comment on that more. As I mentioned before, Senator, I think almost all of our judges are great. They do a wonderful job. But we do have a handful of judges that wanted to be social workers or wanted to be legislators. And I believe that causes some of the issues that we do have today. But I'm going to let, from a district attorney's perspective, weigh in.
And we'll let Mr. Jenkins from our office is going to comment on this in particular, Senator Jones. And however, you know, it's a question is where are we going to draw the lines in terms of what sorts of behaviors? And here again, we're talking about felons in possession of firearms, and of course, that's a high volume of the crime we're seeing and a high volume of the gang crime we're seeing, and also where additional measures obviously are going to be needed in place.
Okay. All right. Thank you. Thank you.
Thank you.
Any other questions from the committee for Senator Albers and Mr. Carlson? All right. Thank you.
Thank you.
And next we do have George Jenkins. And you're also with the Fulton County District Attorney's Office. Okay.
Thank you, everyone.
Good afternoon.
Good afternoon.
All right, the floor is yours.
Oh,
Yeah.
you want to be speaking on that issue? I apologize. This is my first time, so bear
Oh,
with
that's
me,
okay. No, you're good.
with this, and then that issue, Senator Jones, in connection with, and not speaking to, because we, the judges that we have in Fulton County are some of the hardest working judges, if not the hardest working judges in the state of Georgia, and so we're not here to opine on their positions. But I will say is this, because of the volume of cases that we do have in the 15 years that I've been at the Fulton County District Attorney's Office and also in Cleveland, Ohio, people get numb to firearms cases. It comes like if it was something, if it was a misdemeanor offense. What I mean by that is this, it's just so frequent that when you see that charge, it doesn't give you shock, it doesn't give you the pause to consider what do we have here, what's going on. And so with the, I guess, elevation in the mandatory minimum in a case like this, will give the court, give the parties, give our victims a position in which they can say that we are paying attention to what's going on in the streets of Atlanta and through this state, where I'm sure many of you have seen, in which we have an active case in our office at this time, where you have a family driving into work at 7 o'clock in the morning in Metropolitan, and a road rage incident in which, unfortunately, because of where we are, instead of what may have resulted in a curse word or, what you say, the middle finger, now is the finger on a trigger. And now we have a citizen of our county in Grady with a bullet in our back at this point. And so what we have here is that we have to do something about it. We kind of not ignore. Number one, we know we have the volume, but without citizens, without the public knowing that we are willing to make a change, and that change going to be hard. Some may not agree with it, but something has to be done, and that's one of the tools that we have and that we should have as prosecutors and as those who are prepared to do what's right for the citizens of this county.
We have a question from Senator Jones.
Correct. So then my question becomes, but isn't that jurisdictional specific, what you're describing? In other words, certainly in Atlanta, and it's a problem. It's a problem anywhere for a convicted felon to have a firearm. But certainly in Atlanta, you may have a numbness that exists, but I'm not sure if that same numbness is going to exist in Valdosta or even in Augusta or Savannah. Same way in Atlanta, a murder might go down to disorderly conduct because of volume. In Augusta, a murder is a murder. You see what I'm saying? So, I mean, what you're describing kind of tells me why not allow the individual jurisdictions to kind of have that discretion.
Well, unfortunately, and while they may not have the same volume that we have, there is an uptick in across offices, and we speak to our colleagues across the state, whether it be in North Georgia, out east in Chatham County, or in the south, in middle Georgia. This is a problem that's pervasive around the state. And so while we have, because there are more people here in Fulton County, Metro Atlanta, we deal with these issues but there's an uptick in gun violence and road rage incidents, not just here in the metro area, but across the state, and certainly in other parts of the country. And unfortunately, I happen to be from Cleveland, Ohio, which I still go to travel, and this issue is something that's pervasive there as well. As a matter of fact, just as violent, if not more so. So I don't know, I'm not a social scientist, but I can tell you that what I see in terms of the volume, the cases, and the conduct of citizens in our communities are just so quick upon impulse to use guns and their response to disputes or lack of dispute resolution issues that they may have. And so, like I said, what commonly affected us before COVID and this situation in the last few years, and now resulting in the pulling of a trigger. And that happens here in Atlanta and everywhere. So it applies just in every office and certainly major offices that we talk to, whether it's through PAC or just cases that we refer out for conflicts, what they are dealing with as well. And so this issue is greater than just Atlanta.
Any other questions from the committee for Mr. Jenkins? Senator Hatchett.
Thank you, Mr. Jenkins. I wanted to ask you about Section 8 of this bill right now, dealing with motions and limiting.
Yes.
I understand the intent of this bill is to somehow streamline the trial process in general, but, you know, with how backlogged the courts are, the discretion that we give our judges in being able to make these evidentiary rulings on the fly, is this going to help streamline the process, or is it going to slow it down? And then I guess part two of this, would this be another avenue for ineffective counsel claims if a defense attorney were to not file a motion limiting ahead of trial when a defendant may argue they should have?
Well, first of all, thank you for that question. And I can tell you as a prosecutor and speaking with our appellate attorneys and issues that I've had to deal with in terms of people that I've convicted in felony jury trials, I believe the process with that language would help make our courts more efficient. And specifically as a trial attorney, dealing with issues, certainly in complex cases that we have, prior to going to trial, prior to picking a jury. Now, it may seem up front like, oh, it's it's going to require more work, but unfortunately, that's what the public is tasked us to do, and that applies certainly to our office and the judges in Fulton County. And I can tell you this in terms of my experience. I recall, and specifically, what I think this is it gives the public the right to have a say on how justice and courts are administered and what they do in the processes that we create here in Georgia. And what I mean by that is this. I tell you many times, and I've experienced this, and I'm not calling out any judges, but there's a practice. Doing things on the fly sometimes is not advantageous to the entirety of a case that may go to trial, that may come back on appeal for different reasons. And the reason is that there wasn't an effective ruling by the court during the pretrial process, or there was no ruling at all. I can tell you that I've been on trial some over the years where, especially in cases, high-profile drug cases as such, in which judges sometimes may not want to rule on a motion to suppress until after we pick the jury and jeopardy has attached, and then make a ruling afterwards. And certainly that would impact our decision to go to trial in the first place had we known that up front. And certainly matters in which that applies to the defense counsel in that matter. And so in addition to that, I'm going to give you an example of why I think this is important, as I was discussing with some of our appellate attorneys. Many years, there's an issue for people that I've convicted over the years, or many of my colleagues, that challenge their convictions. And it's something our appellate attorneys and attorneys across the state have dealt with. And what happens when they file these motions to suppress, and it happens for years, it kind of created a ruling from this, not kind of, but it did, a ruling from the Supreme Court in Owen versus the state in 2018. And essentially what it was addressing was many of our defendants were sitting and waiting for motions for new trial for years without addressing that issue. For whatever reason, many of our trial courts were not pushing these cases along, and the rights of these defendants were essentially, they weren't even having those rights affected or addressed by this court. And so what the court did, promulgated two rules. That is Superior Court Rule 39.3.1 and 42.1, essentially mandating that trial courts set a time limit as to when they file these motions and a status for such to take care of these matters. And so and I use as an example of saying, hey, it's important before the Supreme Court weighs in on it, why don't you let the citizens of this state say, hey, we want efficient courts, we want rulings that'll be beneficial to all parties, in these matters, and quite frankly, we do it anyway. Many times in cases where we have motions and have hearings prior to court, we end up writing those decisions on behalf of some justice, and we take that responsibility. And so it's not a hard thing to do. It would make it more efficient and give both parties, both the defendant and the state, an opportunity to appeal issues that they believe are relevant, may have an issue that may impact their decision to go to trial. And so that will cut down on a whole lot of litigation that without it, they're dealing with, and that we currently are dealing with at this time.
Can I have a follow-up question, Mr. Chairman? So, and I appreciate that answer, and I think I understand where you're coming from. I guess the second question I have to follow up on that is, it says where a party can reasonably anticipate an evidentiary issue to be previewed or decided in advance of trial. Where does the line get drawn? I mean, complex cases could involve hundreds of pieces of evidence, and obviously you can reasonably anticipate an argument as to the relevance or the whether or not it should be properly admitted. Is this, are we basically trying to create a rule where attorneys would have to file these motions in limine on every piece of evidence that they could reasonably anticipate the other side disagreeing with them on prior to trial?
Well, I'll tell you this, I don't want to get into trial strategy, but I can tell you that bringing these issues and raising them early to the court is a good thing. I know it's difficult, and look, complicated cases it's certainly something that we're just going to have to deal with. In our opinions and our practice as criminal litigators, and certainly applies to civil lawyers as well, in that down the line, when we have these complicated cases, when you have large cases, it's generally you have a lot of appellate issues that you have to deal with, assignments of error and such. And so to limit and to streamline that process of what the court has to review so they can make a decision, get the information, it depends on what they receive from the trial court to, to expedite that process. And many times when you have rulings that are not made, rulings that are certainly no record is produced whatsoever, you have the appellate courts floundering as to and trying to figure out what happened, what's going on here, and making this process last longer than it necessarily should. It is just something that is, I know many may not like it, but it is, and I can tell you of someone who's practiced in this courthouse right down the street, and for many other of my colleagues, that there are many times in which appellate attorneys are coming to us saying, hey, what happened in this matter? What was the ruling? What was the decision by the court? And something we simply don't have. And so I think it's fair for both parties, not just for the state, but for our defendants and other parties, to flush these issues out, and so you can effectively try a case when you have to do so, and decisions are made in which I can tell you that it saves a lot of jury trials because of the pretrial rulings and any other issues that can be, shifted out prior to going to trial will lessen our jury trial system in the first place. And so while it may take some more energy and effort on behalf of our litigators and the court and room, it's worth it, and worth it to our citizens.
Senator Jones.
Thank you, Mr. Chair. So my question is on that line, on that area, because it was, I think, suggested that may could be inserted. Well, if may is inserted, to me, I'm not sure it helps the situation that you're describing. I don't think it will do anything. Then if we say should, then we're in another gray area, because now the attorney doesn't file it. We're not saying shall. The attorney doesn't file it. The judge is saying, well, I don't know if I can allow you to do this or not, because the legislature, quite frankly, wasn't clear. They said should. He says, I can't let you file. I'm going to decide I'm not going to allow you to file this because the legislature did say should. And everybody in that courtroom, to me, is sitting there knowing well, if I should have filed it and I didn't, we're coming back in a year to retry this case because it's ineffective. I don't know how to get out of that box necessarily, but I think that's the box we're about to place ourselves in, because I don't know if may does anything to help what you're describing, and I'm not sure what should really does.
And I understand, the question. This, and it's difficult, but I can tell you this, that I have to err on the side of a more directive and suggestive wording. Now, shall, I would refrain from that, but should, I think would put the onus on the parties to do the diligence from what the citizens of this county elected them to do, and for us that work on behalf of the people. And so that's going to put an onus on us, the state, and it should put an onus on the defendants, defense counsel in this case, to save and to do what's correct in this matter. And so if I'm going to choose between the two words, I'd like to say should than may in these matters, because it will prevent, at least in my opinion and in the opinion of my colleagues here, Mr. Carlson and others here, in connection with this proposed legislation, that we have to do something, and we have to encourage the active conduct of the parties that this system is built to hope and to help, excuse my language there, in this case. And so I understand there is a between may and should. I would err on the side of should, because there should be a directive, and I have a responsibility as a prosecutor, as an elected, and the parties have a responsibility to conduct themselves and to operate as attorneys and litigators on the benefit of the people and their clients. And so by doing so, I think should is the language that's appropriate in this case. That's my position.
All right, no other questions, Mr. Jenkins. Thank you.
Thank you.
Next, we have April Ross from the Georgia Commission on Family Violence. Good evening.
Good afternoon to the committee. Thank you, Senator Strickland, Chairman Strickland, my apologies. It's exciting to be here in the presence of some of my former colleagues at the Fulton DA's office, where I was for many years. But I'm not here in that capacity today, and I do not envy their position to have to discuss all of these evidentiary pieces. I am not here for that part. I was invited here by Mr. Carlson to talk a little bit about the sort of the factual and statistical issues for why a presumption in favor of allowing previous acts of domestic violence would be favorable in this bill. And also to, I think I would like to, I don't have the most current version. I did not have, in my rushing out, I did not get the right copy of the current substitute. So I am, but I'll make a proposal as well. But one of the things that is the imperative of the Georgia Commission on Family Violence. Oh, thank you so much, George.
Tell me what page do you need?
The definition, I'll show you. Of the two. The imperative of the Georgia Commission on Family Violence is to prioritize victim safety and offender accountability, and to make recommendations that would support that directive. One of the things that has been more than a 15-year project of the Commission is the Fatality Review Project. And it is an extremely important project that we've maintained. For the first 15 years of the project, from 2004 to 2018, they studied specific fatalities and looked at, after of course they had happened unfortunately, but did a backward look and delved into what those cases tell us. And one of the most key things that came out of the Fatality Review is how important what we call lethality indicators are. what we know about domestic violence offenders and people in abusive relationships is that domestic violence is often continuous and escalating in nature, and that by the time a case has reached law enforcement and the court's attention, it is rarely the first time an incident of family violence has occurred between the parties. And so it's, to me, very critical that when someone is facing accountability for family violence offenses in our state, that we allow the court and the jury to have the benefit of the best full picture that they can have. And the only way to do that is to allow the opportunity to see the history of family violence. Another reason why is because in the lethality cases reviewed over the course of 15 years of the Fatality Review Project, what we learned is that 91% of those fatal cases had a previous known history of domestic violence that was involved. That may not have always been a criminal case. It could have been a number of things. And so what I do like about this bill is the ability to give a presumption in favor of previous acts in history of domestic violence. And so I'm very excited that it is moving in that direction. The thing I wanted to point out, and this could be, George, it would be helpful here if you, let me start on the definition of family violence felony. I believe that's where it is. I don't know the line numbers right now.
Are we talking about this section right here?
Okay, yeah, it looks like some language has been changed, so.
Yeah, some language has been changed.
What I wasn't sure about, all right, so. When we talk about the mandatory 5 years, I was wanting to ask for clarity on, or potentially propose that there be clarity given on 2A subsection 2 for the offense. It says also provided that the offense for which the person is on probation or has been previously convicted was a domestic violence felony, or involved the occurrence of an act of family violence. And I was not clear if that means an act of family violence as defined by 1913-1, or an act of family violence meaning any act that is proven or basically from the history of the couple. And I think that's a little unclear in the bill, and I would say that it would need clarity in order to be effective for people to know.
Which line are you on right now?
I apologize. I am on lines 101 through 103 through 105. The part that's the most kind of ambiguous to me is or involve the occurrence of an act of family violence. We know what family violence offenses are according to our code section. And then now we have this new definition of a domestic violence felony and what that entails. And so I just think that it may be helpful to add, if that or involve the occurrence of an act of family violence, it may be important to add the code section that we're referencing for the Family Violence Act, so that it must fall within that and it's not ambiguous as to.
If you look at line 78 before, on the page before, I think that's what we're attempting to do there, because family
Okay.
violence is defined, and it does make that cross-reference you're talking about to 19-13-1.
Yes, that is okay. That's helpful. The other thing that I wanted to point out is in section 9, the big paragraph, subsection A, lines 237 through 245, and I think the attempt here is to make sure that we encompass the range of relationships and that we recognize as falling under family violence relationships. And I do applaud that. I love that it is also recognizing dating relationships and people who have children together. But one thing I'll point out that we recognized last year when we passed the Dating Violence Protective Order Act was that we included people with whom a current pregnancy is going on. And I think it may be important here to try to add language that, or a couple between whom a current pregnancy has developed. That may be, allows that a pregnant woman, or if there's an instance where there's a case where there's a pregnant woman involved, but they don't currently already have a child together, that will take out that gray area, which was also something we had in our current Family Violence Act that the Dating Violence Protective Order Act sought to remedy. So
And which line are you on?
it would be towards the bottom of subsection A, down where lines 243 through 245. So a person with whom the accused has a child or child in common, I would say, or between whom a current pregnancy has developed. And those were my only questions or recommendations as to the language in the bill.
All right, thank you, Ms. Ross. Any questions for her from the committee? All right, no questions. Thank you.
Thank you so
Appreciate
much.
it. Next, we have Wes Taylor with the Council for State Court Judges. Good afternoon.
Good afternoon, Senators. Thank you all for letting me be here. Good to see you, Senator
I
Cowley.
didn't recognize you as our judge of the day as well, right?
Well, no, there's a number of judges out here, so.
I know.
And,
That's why I shouldn't recognize any. I get in trouble.
Exactly. One of the things that I want to tell you about is really, I'm here to talk about just a couple of the procedural sections in the bill. I'm not here to talk about the substantive issues. I'm a lowly state court judge, so I deal with misdemeanors and civil cases. So most of the substance of this bill, I would have no jurisdiction over. But what the bill does do is it affects all of the classes of court with a couple of the sections that it has. And a couple of these things you've already hit on and talked about, and I just want to mention a couple of things real quickly. And one is that Section 8 about motions in limine. I will say this, motions in limine are already allowed in the inherent powers of the courts. I'm not really sure this does anything. And so one of the things that I would worry about is that if it's intended or if there's this idea that it would be used to say that a lawyer was ineffective in the assistance of counsel, is that we would be inundated with these generic motions in limine, which we already get. And you could talk to some of the civil lawyers, they know. They're filed all the time. And one of the things that I would hate to see is for that practice to carry over into the criminal arena. So that's just one.
You think putting may instead of should on line 217 will help on that, or are you still concerned about having any of this?
I'm just saying that if you use may or should, it doesn't give any more power to the courts that they already have, and it doesn't take away any. So I think it just doesn't really do anything. That's all. Now, it may be some other reason why y'all want to do it, but I'm not sure it has any effect. So then I did want to quickly turn to Section 10, and the only issue really that the state court judges have with the amendment, and I think the amendment makes a lot of sense here, but is, as you hit on, was C2, where it talks about notwithstanding the provisions of other subsections of this code section, to the contrary, no trial shall be conducted remotely except by the consent of the parties. One is, I don't know if you're intending for that to be criminal trials, if you're intending to incorporate civil trials, if you're intending to incorporate just jury trials. One of the things that this language does, and I'll just bring to your attention, is we have in state court, we have a number of cases where the defendant doesn't respond, doesn't file an answer. And those go into what we call default, which is all of the well-pled allegations in the complaint are admitted by the defendant. Well, in many of those instances, the damages aren't decided because they're liquidated or they're not pled in the complaint. And so we have to have a trial on those damages. And oftentimes those trials are conducted without a jury. And so where you don't have the defendant who's ever responded, and you have to give notice, which we do. You give notice to the defendant to show up because they can show up at the damages hearing. They can participate in that. If we were to leave this like this, where it says except by the consent of the parties, I do worry because we do conduct video trials now. I worry that then we have to get the consent of somebody who's never shown up and will never show up. And then we can't do it by video. And that places an onerous burden on the courts. It's what I used to do, but I could tell you it's very inefficient. And so it would be much more efficient, I think, if we could, and I'm just suggesting this, if you're trying to deal with jury trials, you could deal with that, you could address that, or if it's addressed just to criminal trials. But if it's in the civil context, I would recommend, or I would maybe offer to this body that y'all think about using language instead of saying except by the consent of the parties, saying over the objection of any party, so that you accomplish the same goal. If that is that if somebody doesn't want to have a video conference trial, that they could tell the judge, look, I don't want to do this. And then they don't have to, and the judge can't tell them you have to. I can understand that if that's what y'all's, if that's the will, fine. But I'm just offering that as if that's what you're trying to accomplish, that we just change that language slightly. And I'm here to answer any questions y'all have for me. I could do the best I can.
Any questions for Judge Taylor? All right, thank you.
Okay.
Appreciate your
Thank
help
you.
on this.
Thank you very much for your time.
Next, we have John Floyd, Fulton County District Attorney's Office, a special assistant.
Correct.
If I'm reading your handwriting.
And if you can, you're one of the few, Mr. Chairman. Thank you. It's a pleasure to be here again for me, if perhaps not for everybody, I don't know. But this will probably be my last visit. My focus is on the venue provisions here in the Gang Act, and I wanted to address how we've altered this, amended it in the substitute, and why, and to give you a bit of context. So I've been doing this a while. I've been litigating RICO cases all my career. I've written the only book on state RICO statutes that exists, not a bestseller, but there it is. I've assisted DAs in the Attorney General's office in about 10 different jurisdictions over the years. So I've got some perspective on this. I've also helped write some of the amendments to the RICO statute and to the gang statute, and working extensively with both Mr. Carlson and Mr. Melvin. So what we have here, to give you perspective on the gang statute, is it is really a more focused type of RICO statute. Its linear descendant is the California STEP Act, Street Terrorism Enforcement and Prevention Act. And over the years, it's evolved quite a bit here in Georgia. It's the most powerful statute on this issue in the country. It trues up with RICO in a number of different ways, but not all of them. And while RICO has a venue provision, the Gang Act does not. And so the idea this year was to give it a venue provision, and to give it one that's fairly consistent with RICO, because sometimes we have found we'll use both statutes in one particular case. Sometimes, because a RICO enterprise and a gang are very similar. The RICO definition is broader, the gang definition is more focused for that specific problem. Sometimes we get people who are not really associates or members of gangs, they're working together with gang members. They can make money selling them drugs, they can make money selling them guns, etc. So sometimes we use both statutes. Sometimes we use RICO where the Gang Act doesn't apply. Sometimes we use only the Gang Act. Georgia prosecutors are fortunate in that we have a level of flexibility that really no one else in the country has. including our federal colleagues. But there was a bit of a gap on this venue issue. And so we have, the original provision was in essence a copy of the RICO provision. That doesn't fit terribly well as we thought about it more, simply because of the slightly different scope and evolution of the Gang Act. So we put a finding, we've added a finding to the legislative findings of fact, which I think is just a fairly straightforward statement of what gangs are and what they do. They really are a form of criminal conspiracy, a criminal enterprise. Unlike a RICO enterprise, they don't have, it's not possible for them to have a lawful purpose. They are inherently criminal. Then, as Mr. Carlson said, we tailored the venue provisions to each of the specific subsections that create, that define the violations, so that they would fit appropriately and to avoid ambiguities. That's the purpose of what's been done. The question then becomes, are we creating problems? Have we gone too far, et cetera? Okay, and the point here is this. It is not a remarkable provision. This really reflects in this context what general conspiracy law is. In the state of Georgia, if somebody's a member of a conspiracy, that crime is committed in any county in which any overt act is committed. That's been the law for at least 100 years. So we're not introducing some wild new concept here. Under RICO, which has functioned perfectly well for 42 years in this state, the crime can be charged in any county in which any act of racketeering activity occurs, any overt act in furtherance of a RICO conspiracy, any place where property was obtained or maintained, any county it was transported through. That's broad, but it's broad for a reason. It's broad because gangs are dynamic, they are mobile, they are evolutionary. They are not bound by the geographical restrictions that bind prosecutors in most circumstances. They have a real advantage there. We are at a disadvantage there. We would like to eliminate that disparity. The question then, I think, becomes, and I've heard some expressions of concern, will this lead to competition between DAs, for want of a better term, poaching? Okay. I think what you have seen over and over again is at this moment we all have more to do than we can possibly handle. And so the last thing anybody really wants to do is to go take cases from a colleague. But there are cases that really, historically, and I've done this all over the state, with RICO this concern was brought up. The problem is not refereeing between two DAs who want to bring a RICO case. The problem is getting a DA to bring a RICO case. This is not something where there are tugs of war. I have never seen one in 25 years of assisting prosecutors in this state. And so it's a hypothetical problem that has the potential to get in the way of solving a real problem. We have very broad venue statutes elsewhere. Our theft statute, any place where control is exercised over the stolen property is a place where venue can be brought. There are no shortage of thefts in Georgia. It happens all the time. We don't have competition between DAs. To give you an example of a hypothetical problem that could be conjured here, somebody steals something of value, say it's worth $10,000, a painting, and they steal it in Fulton County. They drive it to Savannah. That's about 15 different counties that have jurisdiction under the statutes. You never see a fight over that. You just don't. Nobody is itching along the way to grab that case. It doesn't happen. It gets worked out between adults because that's how we do things. The gang cases that occur in Metro Atlanta frequently have acts of gang activity, or if it were a RICO predicate activity, that occur in 3, 4, and 5 different counties. We're not seeing competition for those cases. In fact, if there is a criticism to be made, it's perhaps being a little too eager to give it up as opposed to take it. But practical experience shows that the DAs work this out just fine between themselves on a day-to-day basis. Another example is the identity theft statute. The General Assembly gave the Attorney General direct prosecution jurisdiction along with DAs over identity theft in 2015. So we have almost 7 years experience with that. It is the broadest of venue statutes, I think, in the state. Any place where that identity, the information was taken, any place where it is used, and any place where it is possessed is a place where venue lies under the statute. There are thousands of identity theft, well, probably tens of thousands of identity thefts that occur every year in Georgia. Hundreds and perhaps thousands are actually prosecuted. The Attorney General has that dual jurisdiction here. There are no conflicts over this. We just haven't seen them. It just isn't happening. And so I hope that to the extent this is a specter that's raised formally or informally with you, that you will not be concerned with it, because experience shows that the prosecutors in the state do very well working with each other on broad venue statutes. This is not, unlike identity theft, unlike theft, the Gang Act cases are not brought all the time. Right now, I believe Fulton County is the most prolific. We're bringing one about every 3 months. That may increase as resources increase, but that gives you a sense of, the larger RICO and Gang Act cases combined. There are more cases that have Gang Act without RICO in it. But this is not an everyday thing like a theft case or an identity fraud case. It is relatively rare. Most jurisdictions don't bring these cases. That's unfortunate, but that's a fact. But the concern about boundaries or territories is not something that should be allowed to get in the way of effective prosecutions. We're bringing cases with 10 and 20 and 30 and 40 defendants now, because that's what we need. And we need the tools to get them, as many of them, in the same courtroom, in front of the same jury at the same time, so that jury can understand what they are doing, the havoc they are wreaking, and the toll that they are taking. And that's how you do it. You get them all there and in one place, and you tell the whole story. The tool that the defendant uses is to try to break it up and make sure the jury does not see the full story, does not understand the full scope of that gang's activities and the consequences that flow from it. Our job is to break down those barriers wherever we can and to bring those effective prosecutions. And where we can do it, they always result in convictions. They always result in pleas. It's the most effective combination of tools we have. This will make it more effective.
All right. Thank you, Mr. Floyd. Any questions from the committee? All right, thank you.
Thank you very much.
And last person signed up to speak is Mr. John Melvin with the GBI.
Everything I was going to say has been addressed, Senators. I'm here for questions. The GBI supports the bill.
All right, thank you. So at this point, Senator Alvarez, you want to come back up? Is there any final comments on any of the proposed amendments? Keep it kind of quickly if we want to.
No, Mr. Chairman, I appreciate the points that were brought up. I think, specifically of consistency for video was brought up. Your concern in the beginning of should to may. If that brings comfort to the chairman, we're happy to address that. Okay. And I do think the other part mentioned from His Honor about somebody objecting to not having a video hearing makes a whole lot of good sense.
Yeah.
Mike, anything to add?
All right, you do have another question from the committee, Senator Cowsert.
Thank you, Mr. Chairman. Chairman Alvarez, I wasn't here earlier, but at an earlier meeting, we were discussing the bill, and on page 13, up at line 293, when it discussed the video proceedings, it makes it clear, and this is what Judge Taylor was talking about a minute ago, that no trial shall be conducted remotely except by the consent of all parties. I expressed the concern that that ought to also include evidentiary hearings where witnesses are brought before the court. I think I could remedy this by simply inserting those words, or evidentiary hearing, after no trial. I discussed it with you briefly at the last hearing, but I don't know if that came up today. Is
That did not
Okay.
specifically come up, but I think that makes perfect sense. And then except for, or the last few words, it says except by the consent of the parties, it would be unless there's objection by the parties. This way, it would proceed unless somebody says otherwise.
So
I think
you
it
would
was-
change except by the consent of the parties to if objected to by either party.
Correct.
Over the objection of
Over the
any party.
objection. Right. Thank you. The
What's
whole chorus.
what's legislative counsel say about that as far as how to word that?
Over objection of any of the parties is how I have it noted, that if you were to proceed with that amendment, that's kind of how I have it sketched out. Over objection of any of the parties.
And now let's add in Senator Cowsert's point, though, if he's making that amendment.
So
I just added or evidentiary hearing after no trial.
So
I'm
on
just thinking, yeah.
293 would read after the comma, excuse me, no trial or evidentiary hearing shall be conducted. We've got, currently it says remotely, but the issue of video conferencing, I think you're going to come back to. No trial or evidentiary hearing shall be conducted remotely over objection of any of the parties.
So if you'll hold that thought, do you have any other questions?
No, that's it.
Let's get to the posture where we can make amendments. Do we have a motion on the bill? Senator Kirkpatrick.
Move to pass.
The motion do pass by committee substitute LC 490857S. Do we have a second? Second by Senator Watson. Senator Cowsett, would you like to offer the amendment?
I would offer the amendment as previously stated on line 293, following the word trial, to insert or evidentiary hearing, and then following remotely, delete the remainder of that sentence and in its place say over objection by any, was it any party or any of the parties?
Any of the parties?
Any of the parties.
Do we have a second for that amendment?
Second.
All right, we have a second, Senator Kennedy. Discussion on the amendment, Senator Jones? Okay. All those in favor of the amendment, please raise your hand. It is unanimous, so 8. All right, so Senator Kirkpatrick, do you have other amendments?
Mr. Chair. On line 105, just in an abundance of caution to address the point raised by Ms. Ross, I'd like to add at the end of that sentence, as defined in 19-13-1.
The only thing with that, I think it's already defined on line 78. Family violence is a defined term. Let me ask Ledge Counsel, do we need to state that again, or is it already defined?
I don't believe there's a need to state it again. I did review, I think that is the only use of that term, so you would have the choice of striking the definition or using as described in, but it's covered either way.
Okay.
You want to withdraw that amendment?
Sure, I have one more.
You have 2 more, don't you?
Well, he didn't, he took my other
Okay, all right.
one. Line 217, change should to may.
Line 217, change the word should to may. So it'll say motion in limine may be filed prior to trial. Do we have a second on that amendment?
Second.
We have a second from Senator Parent. Any discussion? Discussion, Senator Hatchett.
I would like to talk about this a little bit more, because if the way that it's written, if we put may in there, I don't see the purpose, because this is already the way that we operate our courts. If we put may in there, it's kind of just adding, it's kind of redundant.
Well, it could be suggestive to parties. It codifies it. But I think that the issue is if you put should, it's not clear what should means. Is should a shall? And then are you required in every trial, civil or criminal, to file motions in limine, or do you waive objections by not doing that? That's the other side of that. Senator Cowser, do you have, Senator Kennedy, one of y'all push your button. Do you have a comment on that?
It's me, Mr. Chairman. No, I think Senator Hatchett really raised the issue and the concern. I'm not sure what it does if we take it to may.
Could we make a
Either.
comment on that?
Pardon?
Well, there is, if I may, sorry to
Well, maybe
use
you
that
should.
word. Yeah, well, should I or may I?
You see, there's an example.
Depends on who you ask, as they say. There is this concern as far as taking the right that is generally there and recognized in order to be able to file motions in limine pre-trial in advance. Whether or not you could have a judge issue a scheduling order or a case management order and say, oh no, that motion should have been filed 2 weeks ahead of time or 3 weeks ahead of time, or no, now we're at a point where you're off my schedule. So having this language here with the word may, which of course was not how it was originally presented, but recognize that would carve out that right and that ability for counsel to be able to exercise the ability to file a motion in limine, and we risk also losing the language that comes a little bit later in the statute, providing courts with guidance as to when those should be handled pre-trial. So there is a situation out there, and if counsel needs to file or express that motion in limine, and somehow there might be a scheduling order out there, again, there a case management order that might try to make a dictate as to its form, as to its content, or even as to its timing, which having this language in there in the form of may would help preserve that right for litigants.
Any other comments from the committee? Well, we have for you law students, this is what you get to look forward to, right? Arguing over should versus may. We have a motion on the floor with a second that would change should to may. All those in favor of the amendment, please raise your hand. 1, 2, 3, 4. Okay. It passes.
And again, recognizing again our office's position was should would be preferred, but
I understand.
We're supporting the bill.
All right. Do we have any other amendments?
May I make a suggestion if somebody in the committee might want to offer it for consistency's sake between remote and video conference?
That's what I was about to get to. So we looked up the Superior Court rules, and video conference by video conference is the phrase they use. I think by video conferencing is also used. And I will, if the committee wants to do this, and I'll refer to Ledge Counsel, there's 3 places I saw it, lines 293, 294, and 303. Do you want to comment on that?
I looked a little closer at the Superior Court rules. 9.1 also allows for telephone conferencing. So I don't know if you want to refer universally to telephone or video conferencing or telephone and video conferencing.
Yeah. Probably. I don't know any reason not to, right, to make sure, because your intent was to be consistent. Remotely was meant to cover, let me ask you, is it remotely meant to cover telephone and video conferencing?
Yes, I think that would be both. That would make a lot of sense.
Do you want to give us some suggested language? Michael.
Thank you, Mr. Chair. On line 287, where it currently reads, do so by video conference, I would insert a telephone or so that it would read, do so by telephone or video conference. On line 289, at the end, I would insert telephone or before the word video so that it reads telephone or video conferencing. Excuse me, and telephone and video conferencing shall not be authorized. On line 293, where it currently reads no trial shall be conducted remotely, we would replace remotely with shall be conducted by telephone or video conference. Line 294 currently reads where proceedings are conducted remotely. That would read where proceedings are conducted by telephone or video conference. And then on in line 303, where it currently reads state relating to remote proceedings, I would remove the word remote and have that read state relating to proceedings conducted by telephone or video conference.
Does everybody understand the proposed amendment language? Does somebody want to offer that amendment? Senator Kirkpatrick? Do we have a second? Senator Rett? Any discussion on the amendment? All in favor, please raise your hand. The amendment is The amendment was changing, we use the word remotely interchangeably. We also then will say video conferencing, and so we're trying to be consistent. All in favor, raise your hand. All right, it's 8. Any opposed? It's unanimous. There was another amendment. There was one other thing that was suggested on line 290, where this came up at our last hearing. We say we're criminal trial where the accused guilt or innocence, and it was brought up that there's, unless I missed something, not a trial where someone is being proven innocent. Would it be more consistent to strike or innocence on that line?
Sure, makes perfect sense.
Good. Does anybody want to offer that amendment on the committee? Senator Kennedy. We have a second from Senator Rhett. Any discussion on the amendment on line 290, striking or innocence? All in favor, please raise your hand. It's unanimous. Any other amendments on the bill?
Mr. Chairman, if I could, Ms. April Ross brought up an idea on line 244 after the word in common or current pregnancy to be added, which with her great expertise in that area, I think is a very reasonable addition.
We need or between a, do we need another or in there as well for that language?
I
Did you
believe
get
so.
that
I would
proposed
propose a child or current pregnancy in common.
Perfect.
Does everybody understand the proposed amendment? Yeah, can you read it back to us?
On line 244, after the word child would insert or current pregnancy. So the language would read, whom the accused has or had a child or current pregnancy in common.
Somebody want to offer this amendment? Senator Kirkpatrick. Do I have a second? Senator Rhett. Any discussion on the amendment? All in favor, please raise your hand. It is also unanimous. Any other amendments?
No,
Senator
no.
Albert, it's okay to write your bill before you come and not have us write it on the fly.
But, Mr. Chairman, had it not been for the impeccable wisdom of this committee and your leadership, we never would have gotten to this point.
Sure. Another amendment. Senator Hatchett.
A point of clarity from the author regarding, starts at line 98. This regards the possession of a firearm by a convicted felon. As you know, this morning in public safety, we addressed the Coates decision in the Supreme Court from 2019 that really analyzed the word any. And what it meant was that if you had, more than one firearm, you can be charged separately for each one. And one of the points that was brought up in that committee was the judge's discretion to decide whether to stack the sentences or have them serve, if you had 5 firearms, could serve 5 years there. Right here, it looks like if we're going to make it a conviction per, or you would be charged per firearm, and then we're making it a mandatory minimum of 5 years. In the hypotheticals that were proposed this morning, if you had, 20 firearms, would you be exposed to a 100-year sentence based on the way this bill's drafted?
I believe if we look at the bill that you carried at Public Safety a little bit earlier, I thought there was a consistency between these two bills based on what we said. Do you see that otherwise, Senator?
I think there's some discrepancies between the language where there could be an argument for this, and so I wanted to bring that to the attention so we can at least see what your intent is on the bill and where we want to go with this.
Well, I think the way we were explained it, in fact, I think Senator Robertson before me, I'm going to use some of his words, said that before all of those were put into one, and it didn't matter whether they had 23 firearms or one, right? It was going to be one mandatory up to 5-year sentence. In the new way that it's written, that even if they had 20 firearms, you could do it individually, or it would be the judge's discretion to figure out how they wanted to handle the other ones. But that is my understanding the way it reads, but I'm just a night school, law school attendee, according to Senator Cowsred.
I think the language Mr. Chairman, that I'm specifically looking at here is just that no portion of a sentence imposed pursuant to this paragraph shall be suspended, stayed, probated, deferred, or withheld by the sentencing court. And I wish I had the language that we had this morning, but I don't believe that language was in that bill. Okay. It can be concurrent.
Which line are you on in the bill, Senator Hatchett? Get our attention.
This would be line number 106 and 107.
So it has mandatory minimum language there, obviously. And I know there was a comment about it being running concurrent with another offense. Can you run it concurrent with that language? Ben? Senate Research?
I just wanted to point out that the legislature does address this in other bills. I specifically think about felony fleeing, where there's a specific proviso that these offenses can't merge into any other offenses at the same time. And that's not present in this bill.
So would you need new language to make that apply to this?
Well, generally, if a sentence is going to be mandated to run consecutively, that would have to be in the statute. And then with the rule of lenity would take us back to it being able to be run concurrently.
Does that answer your question?
It does.
Okay.
Thank you.
All right. Thank you.
Senator Parent?
Yeah, just really a comment following up on Senator Hatchett's point. I mean, to me, that does expose some of the fallibilities of trying to impose mandatory minimums, because we do take away discretion and the way it intersects with the code as well as the facts on the ground. I mean, I don't know that I think it's the best thing to do in general, and you just laid out a reason that we should be careful. Thank you.
All right. Any other amendments? Any other discussion on the bill before we vote? All right, we have a motion to pass Senate Bill 359, LC 490857S, by substitute as amended by the committee. All those in favor of the motion, please raise your hand. 1, 2, 3. All right. 5, 4, all of those opposed. Yep. Are you going to vote? 3 against. So 5-3, motion carries.
Thank you, Mr. Chairman, and I look forward to following up with any committee members with any specific concerns that we can make adjustments as needed. Thank you.
Thank you. All right, we have one other bill on the agenda. We have Senate Bill 382 by Senator Robertson.
Still with you? Absolutely. All right, sir.
Thank you, Mr. Chairman.
All right, hold on.
Yes, sir.
Let's get some order in the committee room, Senator Robertson. All right, we are working off LC 490686, Senate Bill 382. Senator Robertson, the floor is yours.
Thank you, Mr. Chairman. First of all, I want to apologize for speaking from the gallery. That was not my intention. Mr. Chairman and committee members, this is, and we hear it all the time in this bill, and this is an extremely simple piece of legislation that we're making an adjustment to. The single intent of this legislation is to protect 13-year-old children from being becoming victims of aggravated child molestation, and by doing so, we're clearing up a piece of legislation where the age 13 was inadvertently put into the bill, which would make at the time, which would have made the basis of a charge of aggravated child molestation involving the act of sodomy a misdemeanor. as stated on line 19 in the legislation. So all this bill does is there's a simple strike on line 16 where the victim must be at least 14 years old and less than 16 years old, and this runs basically next to the Romeo and Juliet statute here in Georgia, where the age of consent in Georgia is 16. And with me is the Deputy Director of the GBI, and we are ready to answer any questions should there be any. But it's, again, I think just a simple adjustment.
All right, Mr. Melvin, do you want to say anything as well?
Senator Kirkpatrick, this actually is the result of a conversation with Chief Assistant Treadaway out of your jurisdiction. So I'm 17. This is my 13-year-old girlfriend. As the law currently stands, if I commit an act of child molestation upon her, I am subject to life in prison. But if I commit an act of aggravated child molestation, misdemeanor. That doesn't make sense. We're just asking to get it cleaned up.
Any questions for Mr. Robertson or Mr. Melvin? I already have one person signed up to speak on the bill, Ms. Maisie Lane Girton.
Good afternoon, Chairman
Good
and
afternoon.
committee. I will be very brief. I know the hour is late. I've already spoken to Senator Robertson about this bill. We understand the policy that he's trying to address here. We have no problem with that. But we would like to bring to your attention that by dialing back the age here, it does bring an inconsistency in our law with respect to how we treat 13-year-olds. Today, under 1511-160, which is the law that allows children to be prosecuted as adults for some of the most serious crimes, on our books, that can happen to a 13-year-old. So, if anything, can we be consistent? And I don't know if that means an amendment to this bill. I don't know exactly what it means that I'm asking you for. But if we're going to care for 13-year-olds as the precious things they are, and hold people accountable to the damage they do to them with aggravated child molestation, ought we not also treat them like the valuable young children they are? And even if they're running afoul of the law, allegedly, handle them as such? There's a lot of inconsistencies in our law with the way we treat children, and I just want to bring that one to your attention because it seems pretty egregious to us, especially in light of things like raise the age that are also on your plate. So just raising up that inconsistency and some hope that we could make a difference for those 13-year-olds across the board.
But Gactel doesn't have it's not an opposition to this bill. You're just pointing out another area you'd like to see us address. Is that fair to say?
That's fair to say.
Okay. Any questions for Ms. Girton?
Thank you, Chairman.
Thank you. Can't be this easy.
Yes, sir.
Can't be this easy. But what's the pleasure of the committee?
To do pass, Mr. Chairman.
Oh, do you have a comment?
I was going to ask the author.
Oh,
Sorry.
it's not this easy. Come back up. Senator Hatchett.
Could you go back over the reasoning for changing it from 13 to 14? Because to me, and I'm not disagreeing with what you said earlier, it sounds counterintuitive. So I want to make sure we're voting on the right thing because I think 13-year-olds need to be protected.
Exactly.
It's very counterintuitive, and believe me, the initial meetings we had, we were slicing and dicing individual words, but basically what this is saying, and it was pointed out very, very well. If you read line 16 as originally, the victim is at least 13, but less than 16 years of age.
The Romeo provision, hey, young people fall in love and they do sexual things, right? So the way the law is, this 13-year-old, if I'm 17 and she's 13, if I touch her breast, that's an act of child molestation. And the way the law is written now, I can go to jail for life in prison. Up to, that ain't right. Excuse me. Yeah. But if I commit aggravated child molestation, which involves an act of sodomy, fellatio, for instance, then it's a misdemeanor. Because the way the law stands now, a 17-year-old and a 13-year-old can do that, misdemeanor. But if I just simply touch a breast, life. So we're asking us to raise both, just make them consistent that 14-year-olds is going to be the lowest amount of lowest amount of Romeo and Juliet that we're going to allow. Does that make sense?
Okay, I think I understand what you're saying. So what you're saying is that if it was a, what do they call those, Venn diagrams, I guess the 13-year-old category overlaps in both charges right now,
No,
to
sir, if
where
you
it
look
can
at-
be, sorry.
I'm sorry, Senator. If you look at B2, B2 says that for child molestation, it's the difference between below 18 and 14. That's the cutoff level. And that's Romeo and Juliet level.
4 years.
Okay.
At D2, it takes into account the more serious aggravated child which is aggravated child molestation, and it lowers the victim's age.
It goes from 4 years Romeo and Juliet and expands to 5 for child molestation.
Okay. Okay, I think I understand what you're saying now.
It's pretty counterintuitive.
But this, in essence, would actually provide more protections to
For
13-year-olds, although on its face it looks like you're providing less
And I'm sorry.
by raising the age to 14. But it's actually...
The Romeo and Juliet allow the 14 to 18 already. Because the law specifically says 4 years.
4 years.
Right. At 13, we've expanded it out to 5 years. And then there's the problem.
Okay.
As said, touching, felony, sodomy, misdemeanor. And that's what we're trying to correct by moving the 13-year-old completely out of the arena.
Okay. Thank you, Mr. Chairman.
Any other questions from the committee? We had a motion to pass by Senator Kennedy and a second by Senator Hatchett. Any discussion? All those in favor of the motion, please raise your hand. Any opposed? It is unanimous. Thank you, Senator.
Is that easy?
And with that, we are adjourned. Thank you.